This is a special report from WBRN Radio and on the Boston Red Network. The date, the 10th of April 2019. This is Boston Red from the Jerry Pippin broadcast booth. This is our continual coverage of the murder trial of Justine Damond. We'll call her Ms Damond in this broadcast. Throughout the broadcast, the defendant is Mr Noor, and we are working on a title for this. It probably will be the Noor trial period. We'll be giving obviously a number of reports. We're covering this from day one of the trial, and we'll talk about the elements, the more important elements in a murder trial: the judge, the atmosphere. And in this particular case, what you have is a long-standing affinity for jurors to acquit police officers in the United States. Now, this is for our listeners in Australia to understand what the situation is, and also how the applicable or the law is written. It does give weight to the police officers' so-called state of mind. In other words, if they fear for their life, and you hear that in this trial, if they fear for their life, they can respond by literally shooting dead the person, as it happened in this particular situation. But there's many more elements to this than what has happened. There was a case of a young man in the sister city of St. Paul, Minnesota, named Philando Castile. He was an African American. He was killed by a police officer, and he had a what's called a concealed weapon permit, or a permit to carry a handgun, and he had one, but it was in his pants, and he had on what's called cargo pants. So in other words, reaching into the pocket was not a quick option. And he informed the officer that he did have a gun, and this officer responded by shooting him. Now, it's a little bit different from this particular trial, and we'll get to it in a minute. It was filmed by his fiancée, Philando Castiles, that is, and that was immediately posted to YouTube. And then we also had the police cameras, etc. But the case ended. Basically, the officer involved, the jury believed him, that he feared for his life. And now the composition of that jury was different in the atmosphere in a smaller city, being St. Paul, and the jury, I should say, contained only one African American. Now we'll get into the composition of this jury as we go through the selection process, and want you to listen very carefully to some of the high points in this selection process, because it is a result of what we have. On Tuesday, we had the partner of Justine Damond, Mr. Damond, testifying, and of course relative testimony is always very emotional. The parents of Justine Damond Ruszczyk Damond were in the court, the father, I believe a sister and a stepmother, etc. We'll get into that. We're falling back on the local paper, the Tribune, and then there's news from Australia. Now, this is the former police officer's trial opens on Monday. The date on this is April the 1st. Now, the first time in recent memory on a murder charge. He is charged with murder. This is Noor. The case against Noor is starkly different from other police shootings in that angry people in Minnesota and across it angered people. The national conversation has largely centered around European police officers killing African Americans. But in this case, we have a European woman, Ms Damond, from Australia, that was killed by this Noor. Noor was a police officer at the time of the shooting. He's been since fired. He was charged with second-degree murder, with intent, third-degree murder, and second-degree manslaughter. He pled not guilty to all charges. Experienced defense attorneys who have heard some of the state's most high-profile criminal cases say they're not certain either side has an advantage going into the trial will be watched around the world. No doubt about this, and then they talk about Philando Castile here and his Geronimo Justine, a Latino police officer that shot him. He, of course, was acquitted. And the Tribune, 24 police officers across Minnesota have been cleared of criminal wrongdoing in 15 fatal shootings. And, of course, Yanez was acquitted there of second-degree manslaughter and 2 counts of recklessly discharging his firearm. Now, while the circumstances in both cases are greatly common threads have emerged between the prosecution of Noor and Justine. Prosecutors sought to contrast the defendant's actions to that of other officers to show that the shootings deviated from best practices. Juries don't pay a lot of attention to best practices. The trial arrives in a tight media public restrictions established by the judge Quintens. It will take place in a small courtroom. We talked about that in our previous broadcast and what happened there. We won't recap the shooting. We have other broadcasts that you can find. Quintens has ruled that no one else can testify about Noor's state of mind at the time of the shooting, a critical element in determining whether his actions were reasonable. The law is premised on how he viewed the circumstances and what was reasonable from his perspective. We talked about this a few minutes back. So, how does he see he could not testify? That's Joseph Daly, an emeritus professor of law at a local law school. That's always going to be a very difficult and strategic decision for him and his lawyers to make. Noor's attorneys, of course, haven't said if they'll put him on the stand or not. In the U.S., a defendant is not required to testify against himself. In one of the most famous criminal trials, the so-called trial of the century, the People versus Orenthal James Simpson, O.J. did not testify in that trial. Now, he's got to tell the jury what kind of person he is. This is from a person named Gray, a defense attorney. They are looking over this fella and they want to hear from him. Lots of it in Justine's case is they heard from him and they could tell that he was very distraught. Well, defendants are coached, let's say, in being distraught. Of course, the attorneys didn't comment there. Bob Bennett, who is representing the Damond family in a civil lawsuit, didn't comment also. The charges of murder and manslaughter counts against Noor spanned a breadth of legal definitions that can seem contradictory at times and confusing in others. They all call for the jury to place themselves in Noor's mind at the time of the shooting. Ultimately, the case will hinge on whether the jury believes Noor's perception of the threat was reasonable enough to merit deadly force. Did the police officer have sufficient reason to fear for his life or the life of his partner? That's from another defense attorney, Friedberg. If he did, then they can act with reasonable force. If he did not, he can't. Now, and some more people here. Francis Shear is at the University of Minnesota, has researched and published articles showing that civilians struggle to differentiate legal definitions when addressing a defendant's mindset. The bottom line of the research is that jurors sometimes have a very difficult time applying the law as it is intended. It's tough for a lawyer to explain and for jurors to understand exactly what the differences are between those charges. Now back to Justine's trial. At the time, the jurors focused on the definition of what is, and we talked about this before, culpable negligence. In the week-long deliberation over whether to convict the officers of second-degree manslaughter, one of the three counts against Noor, the majority evidently was able to sway two holdouts after analyzing the legal definition of the charge, said Poussaint. Poussaint was one of the attorneys who described their deliberation as very difficult. Negligence is something that all of us are capable of on a bad day, according to Friedberg. And you hear these generalizations are from defense attorneys. That's incorrect. All of us are not necessarily capable of negligence on a bad day. Negligence to run a stop sign. And this is not a stop sign. This is murder of a woman. Culpable negligence is something most of us would never do because there's an inherent risk in that it would not take driving 100 miles per hour on the sidewalk just because you didn't see someone on the sidewalk. Those kinds of examples don't apply here. People don't drive 100 miles an hour or 100 kilometers an hour on sidewalks, generally speaking. Now, there have been cases where drunk drivers have went on the sidewalks and intentionally ran people down, but that's a different situation there. Those people would be convicted. The jury can acquit or convict Noor on any of a combination of charges. Some defense attorneys say the jurors may want to give each side a break and acquit on the most serious charge and convict on the least serious count. It gives jurors an option. Well, this is almost like voting. Let me move on here with this. This article here is on the 2nd. We were on April Fool's Day there, and it was no joke. This is the research begins on the jurors' names and, of course, addresses. You know that, but nowadays social media is searched. Period. And there were 75 people in the pool of, and they'll have 16. That'll be 12 jurors and 4 what they call alternates. The pool of prospective jurors consists of 50 men, 25 women, 15 of them people of color. Now, they're using the term, went over this once before, people of color. People of color in the U.S. is a very interesting concept, but when we talk about police homicides, we're talking about African Americans, which we euphemistically refer to here as followers of O.J. Simpson, which would be more sympathetic to Justine Ruszczyk Damond. decisions were reached after Quentin's and attorneys reviewed more than half the completed questionnaires. Now, in our last program, if you do a search for it, you'll find that we put the questionnaire out there, and people who were dismissed, and this is some of what they said, is an innocent man. He had a bad mental illness, a man who said Noor was a fast-track hire, who had negative feelings. All this has been described before and has been banted about in the news media. And another juror knew Mr. Damond, and another juror knew the head of the police union. Media access. Now, this is always very important. There's a history in the U.S. going back to the 50s in some jurisdictions that civil trials were actually televised in a black and white, and also criminal trials. And then, of course, we had Court TV. I'm not sure if Court TV is around now or not. That almost remembered his name. A gentleman that used to be with I think he was with ABC, was a reporter for a very long time there. But nonetheless, he founded, one of the founders of Court TV, which specialized in trials and a commentary, and became very, very popular after the OJ trial. So there is a history of the trials. Now, some of the trials, the more graphic things they were talking about here, they would just simply be shown to the jury and not to the TV audience. But the whole idea of televising a trial is as American as apple pie, and this trial should have been televised. At worst, the audio. All we have to, and during the report now, is I have to go through newspaper and TV reports to attempt to find out what the witnesses said. Now, from what little that you heard, and you remember these are at most 2-minute sound bites, and you don't have the transcript to work on, nor do you have an audio of the trial to work on, or the actual proceeding, and then you'd have various analysts and pundits, and a person in our position could highlight it. But in this case, and this is why we're taking some time to go back and move forward. And also where jurors have worked, etc. And is one person here said it could cost as little as $50 a juror, or maybe $500. That's very, very cheap. The American Bar Association has ruled that running online background checks on prospective jurors do not cross any ethical lines. Courts in several states have gone back and forth in recent years on whether such online snoops, violate a juror's privacy. Social media posts deemed inappropriate have gotten jurors thrown off of a jury, and in several cases, and it happened in the OJ, that some juror, and long forgotten, was there and had intended to get on the jury to write a book, and the book was written. Now let me we reported this before. The 75 jurors that were threats to the judges' chambers. We went over the questionnaire. Now, the news media appealed this ban to court, and we'll get to that. This is on the 3rd of April. The jury pool that started at 75 was then down to 59. And the defense attorney here accused the prosecution of singling out Assistant State's Attorney Lofton, in particular, a pattern of inappropriate objections aimed at undermining the questioning of prospective jurors. Plunkett told the judge he was raising the issue to establish a pattern for future mistrial motion if necessary. Now, this is something that always lurks around a criminal proceeding, the chance of a mistrial. And normally that is part of standard procedure in a defense attorney's toolkit, so to speak. Lofton, the DA type, defended his objection, noting that it was not Plunkett's question, but rather his phrasing that was objectionable, because it was asked a prospective jury to speculate on the case, something you can't do. It was during an exchange that Lofton briefly noted that the prosecution is disputing that there was a slap on the squad car. Noor and his partner were riding in before Noor fired the weapon. Lofton did not elaborate. Now, this is where it gets very tricky, because that snap hitting my desk here, you can't hear it. But anyway, the partner, Harrity, was in the driver's seat at the time. Harrity said he heard a voice, a thump somewhere behind him on the squad car, and caught a glimpse of a person's head and shoulders outside of his open window before Noor fired. Now, there's speculation Noor was not even in the vehicle, that he could have gotten out on the passenger side and fired not across Harrity, but across the car, and murdering Justine Damond. And the defense spent most of the day, this would have been Wednesday, just asking jurors their opinion. Jurors were also polled on whether they could set aside any preconceived notions that they have found them, that they have formed based upon previous news coverage. No one excused for knowledge of the case they got from the media. That's kind of troubling there. Said that Plunkett said that her response suggests, now this is two sides disagreed on whether to dismiss a woman, a retired administrative assistant, who said, I believe so, when asked whether she was confident that she could be objective, a creature we don't find in the courtroom. Plunkett said that her response suggested that she'd already made up her mind about the case, but the prosecution argued that any hesitation she may have shown on the stand was a result of being thrust into a high-pressure situation. The judge agreed. The woman was, although she never met Damond, that she identified with her because of their shared interest in community service and spiritual healing. A total of 15 prospective jurors, 7 women and 8 men, were asked to return for a later date for further questioning. So this kind of goes along here, and we'll move on here. Now, this is the actual challenge to the judge's restrictions, which is a First Amendment violation. Now, the hearing was set, but I won't spend much time on it, because the judge had to recant some there. On Monday, 52 remained there, so we already talked about that. Jurors, implicit bias on the minds of attorneys in the Noor case. This is on the 8th of April. It seemed like a simple enough question. Have you ever had any particular positive and negative, and we went over this in the question, experiences with a person of a Somali descent? Studies have shown that people harbor automatic prejudices or negative attitudes and beliefs towards members of other social groups, particularly African Americans. that influence their decision making. The attitude referred to as implicit bias exists outside a person's conscious awareness, control of making them difficult to root out. When race is a salient issue or gender, implicit bias can definitely come into play and can definitely have an impact on decision making by the jury, even the judge, as Mark Bennett, a retired federal judge who has studied the role of implicit bias. We may attach this article, I'm not sure now. One man wrote in his questionnaire he was concerned about how someone in the Somali community treated women. Now, that is another situation, hasn't been brought in yet. Abdul Fattah Mohammed, president of Somali American Bar Association, said it's no surprise that some people harbor prejudice against former police officers, considering the Islamophobia rampant in the nation, we put it at that. Research has shown that racial biases are hardwired into people's mind. One often cites a study where people were shown photos of black and white men while hooked up to an MRI machine. So there have been various studies of this nature. You understand why it happens, reminding jurors that their biases, that they have biases, helps researchers say, but too much talk of prejudice can backfire by leading jurors to think themselves are more objective. Now, Jonathan Kahn, law professor at local Mitchell Hamilton, said that while training aired at countering stereotypes that reduced these biases, every jury will invariably bring some psychological baggage along. Well, yeah, no doubt about that. Now, this is on the 6th. I think I had already went over this. This is rising tension of questioning of jurors. It always happens. And they had bench conferences here. Let's see. He remained defiant, a tone that has colored the last several days of jury selection and on two prior days. Mrs. Plunkett, one of the defense attorneys, has raised the prospect of mistrial. We talked about that before. Said he disagreed with the question that had been attempted as indoctrination. It was important to vet prospective jurors from any strong feelings. Which question them there, but in this trial it hasn't really risen very much there. I recognize very clearly where this is going. The juror may not, Sweeney said, adding that Plunkett was spreading breadcrumbs amongst prospective jurors to further the defense's case. No doubt about this. This Plunkett has been accused of that before. Sweeney, this is one of the told the court that the defense was showing a pattern of questioning and re-questioning prospective jurors about issues that should have been identified much early in the process. The issue with school income came up late Monday when the defense attorney asked the panel whether any of them had concerns about serving on a juror. That after Plunkett spent an hour and a half questioning them on Thursday about this is in a jury setting where you have more, not one-on-one, but a group of 20 or so. Another motion here, I think we talked about this before, the admission of two 3D recreations fly-through videos. The crime scene, no stills from the video created via computer software. They used computer software in the OJ case. That's 25 years ago. Anyway, let's go on here. So jury is finally seated. This is on the, looks like 9th of April, the first day of jury trial. Seated. Defense repeatedly asked prospective jurors last week about training and licensing they received from their jobs. Were they qualified to work on the first day? Well, this wasn't Noor's first day. Anyone disagreeing, there's a difference between experience and qualifications. She said, well, that's an old American fallback, goes back philosophically a very long time. And in terms of political thought, back to David Hume, that a person must experience everything and cannot be based on training and thought processes, which itself is anti-intellectual. But in Noor's particular situation, from what record we know of him, he has pointed guns at people before, and he didn't do very well in his training. He should have never become a police officer. That is haunting everyone. Let me just move on here. And these are some of the jurors. A male, a software developer who recognized Noor's name but hadn't heard about the case. He's a firefighter who is on the panel, should not have been on the panel. A man who immigrated from the Philippines, works for Homeland Security. Usually don't put the law enforcement or quasi-law enforcement people on. Now that would be from the prosecution's situation there. A man who previously served in the Navy, hunting submarines. He must be older than baseball. A woman with experience as a business analyst. Business analysts, accountants particularly, tend to be more conservative. A woman who immigrated from Pakistan said she'd never heard of the Noor case. Well, who knows? So anyway, a coalition of various people had challenged this. What did we learn from the first day? We just do the takeaways here. Prosecutor said the idea that Justine Damond may have slapped the SUV came from, now this is very important here, came from the Minnesota Bureau of Criminal Apprehension agent who speculated that the officer must have been startled by a slap on the squad. Defense said that Noor and his partner Harrity heard a loud bang on the car. Doubtful. Look back there. Ballistic testing and autopsy found that Justine Damond, she was 5'7", was shot in her lower left abdomen. Noor fired his weapon when he saw a figure in the door. Prosecution cited missteps early in the handling of the case, saying the BCA agent initially failed to test for gunshot residue inside the SUV or to interview witnesses. This is what the state's attorney Freeman talked about, but they bungled the whole thing. So he took it on to a grand jury to finish it up. Damond was far enough from the squad car that Harrity also was able to open the driver's side door without touching her. So that's some of the issues brought up here. Now let me move on here. Now this is the emotional testimony of Mr. Damond, her partner. He was out of town at the time, I believe in Las Vegas. He works at a casino as a vice president, some kind of official there. The next call, hold it. Don Damond, text her about 2:26 a.m. The poor woman was dead, but that's the last effort to reach her. He was in Vegas for his work as a vice president and general manager of an entertainment complex. He testified, recalling how by chance how they met. Justine stopped answering her phone after telling Damond that the police had arrived in response to her 911 call. That was her last words to him. And the police called him and said, well, there's been a shooting, and we believed Justine is deceased as a result of the shooting. Damond, after removing his glasses and taking a deep breath, I couldn't believe it, no doubt. Now, the assistant attorney, state's attorney Sweeney, asked if officers had informed him another officer had fatally shot her. He said, no, I imagine not. So this is his testimony. No doubt the relatives were crying. Justine's father, John Ruszczyk, sat in the front row of the courtroom gallery with his son and two other family members, pressed one hand to his face and sobbed. And jurors see this, and it does cause some problems. So Mr. Damond packed his bags and took the next flight to home. And the BCA people finally told him that she was shot by a police officer, and no doubt he couldn't believe it. And let me see, is there anything else here? And Noor acted rashly when firing his weapon, and an unarmed, barefoot civilian clad in pajamas. And he did have a teenage witness that happened to be riding through, told investigators the officers were outside of their vehicle when the shot was fired, and he's expected to testify, although Lofton told jurors that he was not reliable because he'd been drinking alcohol. Oh boy. So that's basically what we have, and it's going to be it's always some contradictions. Now, the cameras that are required to be on were not on, at least not during the shooting. Now, the defense attorney again is researching a possible motion that could require request that some of the audio from the body cameras be excluded from the jury because it would be prejudicial. He did not elaborate on which audio revealed whose body cam it came from. Sweeney said there's absolutely no way to redact audio at this point without stopping the trial. Now, so again, we hear what's going on. And day one, I think we went over this. We did. Okay. Now back. This is from the local public radio. Basically here on the 4th, Judge to weigh media's demand in Noor case. Won't spend our time there. She has relented some. Now let me just jump again here. There was the thump. We went over the thump before. Noor's attorneys argued the officer fired his weapon to protect his terrified partner. That's just ridiculous. Now, prosecutors argued, and this is that the thump was a story made up later, but no police at the scene that night talked about a thump on the squad car. Now, this is not unusual. In these types of crimes, police routinely mix things up as they go. And the unfortunate thing is jurors believe these people. Now, if they believe the thump was made up, the fat lady will sing. Nonetheless, Lofton told jurors that experts will testify Ruszczyk, who was in her pajamas, could not have posed a threat. No doubt about that, she could not have. Because she would have not been holding a gun. And this just goes on. When the defense attorneys called it a tragedy, it is more than a tragedy, and it was he said no crime, but it is a crime. He's trying to the defense attorney, that is, subtly plant in the jurors' minds that it was not a crime. She scorned Woe for trying to talk about an incident where a police officer was ambushed in 2017, trying to slip things in. We're not here for headlines, she told the attorney. And the prosecution ended with what Justine Damond told her partner, Mr Damond, that it was okay the police were there. Oh, did she believe that? And the facts will show that Noor's acts were not those of a criminal. He acted reasonably in the information at hand. That is an absolute lie. And let me see. The jurors, let me get this in here as we wind down our presentation, are 12 men and 4 women, including alternates. 6 appear to be people of color, indigenous, or have identified themselves that way in the questionnaire. 1 woman is a doctor who talked about implicit bias in her profession, noting that people sometimes mistake her for a nurse or a lab technician, which a lot of women in the medical profession are nurses, and not as many lab technicians, and question her knowledge as a doctor. That is not unusual. I've had this happen before also, trying cases, and it's one of those things that occurs. But later in the drama, people find out what's actually going on. But the mindset, and this is a little bit about the American mindset now. People commit crimes in America or do things, as you hear from the political news with the Trump administration, but they do not take responsibility. Now, I'm not talking about personal responsibility. They do not take collective responsibility. It's sort of like we have an epidemic now of measles, and we have some people in the society that believe, not based on science but on hocus pocus, that the various vaccines cause autism. There's been no proof to that. Why do they believe that? Because they want to believe that. But when they are confronted with the science, they just shake their heads, dismiss it, and move on. This is sort of like many of these characters when they are confronted with, say, climate change, where there's Arctic blasts, whatever, floods, and it's proven that it's due to climate change, and they just say, well, so what? So in other words, it's not, the conservatives in America used to always talk about what they called personal responsibility. They don't talk about that anymore. So in other words, that would be Noor's case. Well, it happened. It's kind of like DJ Trump's S-hole nations, and this is S happens. I keep this, and that's basically it. But S did not happen in this case. It's because an individual that was what we called in the old days trigger happy was trigger happy. Shot the woman, and then he and his partner tried to cover it up. There's some evidence of that, because when he was let out on bail, he was informed not to contact his partner, who is still working as a police officer. No First Amendment privacy. This is the judge, Quinton's here, also reversed course on whether to allow graphic video and images of the shooting, the aftermath, to be made public if used as evidence. Quinton initially said she would not allow release of those images, but she had no choice. News organizations, including the public radio, had filed motions, and various others, the ACLU, the NAACP, and Quinton relented, telling the court, "It's clear that I need to follow legal precedent. There is no role of victims' privacy in the First Amendment." Now, historic note, there was talk of special legislation, and even to amend the Constitution after the OJ trial, to give quote-unquote victims more rights. And that was based upon the race of the victims in that case, not of Orenthal James Simpson. But that has disappeared. Freddie, was Goldman? Anyway, he went around drumming this up, and the Brown family, big victim rights thing. We haven't heard much of that. It's sort of like Brown was going to build all these these women's shelters. So far we don't have any record of Brown ever building anything. Anyway, this is let's just get a little bit from Australia here. Australian struggle to process shocking killing this is a headline actually at the public radio. What happened there, circumstances there, summer night in 2017, what actually happened. The fact that she was killed by law enforcement officers, something an American nightmare across newspapers, period. Ben Knight covered the aftermath of the Ruszczyk killing for the Australian broadcasting ABC. Told NPR at the time that his views were looking for anything to explain how this could happen and why U.S. doesn't take measures. Now, one thing to note here, after this was before the killings in New Zealand in Christchurch, the gun laws in Australia are much more lenient than they were in New Zealand, but New Zealand has changed their particular pattern. Now they go on to talk here about Australia and their policing problem. Yes, they do. With Aboriginals in Australia, documented 400 deaths of Aboriginals from everything from medical conditions to injuries. There's no doubt about that. The Australian attitude towards Aboriginals has been simply nothing but racist. Now this is from The News here, ABC. Ms Damond Ruszczyk's fiance breaks down in tears on the newsstand, and the defense said Mr Noor and his partner were on guard when they responded to Ms Damond Ruszczyk's call and feared an ambush. They lied. The former fiancé said informing her family members was the worst call I've ever had to make. Prosecution had questioned why the police officer did not turn on their body cameras until after the fatal shooting. It's apparent why they did not do that. Now, their wedding was planned for August of 2017. The shooting happened in July. Very, very sad. And to finish this up, it's unclear if Noor will testify. It was called by the then Prime Minister Malcolm Trumbull shocking and inexplicable, no doubt about that. Sad. I mean, this whole thing is very, very sad indeed. And they do mention here that she's suing for 50 million US. That would be 7.2 million Australian. And from the Australian, this is in Sydney, I believe, paper on the 10th, and that's where we are. Again, about the fiance there, Mr. Damond. And, he just couldn't believe it. That's basically the same thing. It's a perfect storm with tragic circumstances. No, that's not true. Nonetheless, the prosecutor in his open statement said there's no evidence that Ms. Damond touched the car. Now, they did check for prints there, and she would have given prints because she was not only barefooted, she was barehanded. Let's do the sports now, and we'll look where we are. Okay. Anyway, this is the sports from last night. This is just a heartbreaking story that should never have happened in the U.S. or any place else. But this just goes to show what can happen when there is a poor training, a climate of racism and Islamophobia. Just a very, very sad situation. What more can we say? It's despicable that these types like Harrity and company can get on the stand and just lie. Nonetheless, in the National Basketball Association, Hornets won 24-97 for the Cavaliers. The Pistons 100-93 for the Grizzlies. The Celtics 116-110 for the Wizards. The Heat 122-99 for the 76ers. The Knickerbockers 96-86 over the Bulls. The Raptors are 120-100 over the T-Wolves. The Warriors 112-103 over the Pelicans. The Mavericks 120-109 over the Sun. The Jazz 118-108 over the Nuggets. The Thunder 112-111, a 1-point game over the Rockies. And finally, the Trailblazers 104-102. Magic Johnson, the president of the Lakers, has resigned, and the Lakers have not made the playoffs as he promised. On to Major League Baseball. Cleveland 8-2 over the Tigers. The Blue Jays beat our Red Sox at 7-5. The Rays 10-5 over the White Sox, President Obama's team. The Reds shut out the Marlins 14-zip. The Athletics 13-2 over the Orioles in Camden Yard. And in 10, the Nationals 10-6 over the Phillies. Phillies have lost a few games. Mr. Doolittle was a winner. Anyway, nonetheless, in an interleague play, the Twins are 14-8 over the Mets, and that was in New York. The Cardinals, a game we tuned into, shut out the Dodgers. The Astros 6-3 over the Yankees. The Mariners 6-3 over Kansas City in Kansas City. Atlanta 7-1 over the Rockies in Denver. The D-backs 5-4 over the Rangers. They were in Arizona. Giants finally win one 7-2 over the Padres. Another game we tuned into. And finally, the Angels 8-11 over the Brewers, and they were in California. Brewers won a lot of games. I guess the Cubs were off. And let's see, we had no game. Okay. We'll have games tonight, Wednesday night. The Justine Damond murder trial is what we'll call this, on the 10th of April, 2019, from WBRN Radio and on the Boston Red Network.